This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the fact that every claim presented to an insurance company must be honored with the insured fulfilling the burden to prove the loss was due to a peril insured against, and why lack of evidence supports a motion for summary judgment in favor of an insurer, because to prove a claim for hailstorm damage, admissible evidence of a covered loss is needed from the insured, not from the insurer. Kimberly and Michael Cutchall sued their homeowners insurance provider, Chubb Lloyd's Insurance Company of Texas. Chubb disputed that there was water damage caused by a storm and claims that it already issued payment to the Cutchalls for all of their covered losses. In a case entitled Kimberly and Michael Cutchall versus Chubb Lloyd's Insurance Company of Texas, the United States District Court for the Southern District of Texas on December 31, 2024, ruled on the insurer's motion for summary judgment. Kimberly and Michael Cutchall were insured by Chubb, providing coverage for certain types of damage to their home. The policy insured against risks of physical loss to the property, subject to several exceptions, because no insurance policy covers every possible risk of loss. In September of 2021, the Cutchalls submitted an insurance claim to Chubb for water damage to their house. Chubb retained Nelson Forensics, LLC to inspect the house. The report from Nelson Forensics concluded that the moisture in the house was due to deterioration or deficiencies in the way the house was built, not storm damage. Nelson Forensic prepared a supplemental report later, and that report stated that the roof damage was unrelated to wind or hail from any storm event. Chubb sent a letter to the Cutchalls explaining the results of its investigation, including that the damage to the Cutchalls' house was a result of several different causes of loss, including a hail event prior to 2020, roof distress unrelated to wind or hail, as-built defects, changes in temperature between the interior and the attic space, prior plumbing leaks, and localized movement. Chubb issued a check for $27,385.81 as payment to the Cutchalls for their covered damages, and the Cutchalls never cashed the check. The Cutchalls sued Chubb for breach of contract and bad faith and designated Mr. Halliday, an independent adjuster, Brandon Allen, as experts. Chubb retained a meteorologist, David Finfrock, to assess whether a hailstorm could have damaged the Cutchalls' home on August 16, 2021, as Mr. Allen contended. After analyzing the data relied upon by Mr. Allen, along with multiple other sources of weather data, Mr. Finfrock concluded that there is no evidence of hail at the Cutchalls' address on 16 August 2021. After litigating for a year, Chubb filed a motion for summary judgment on all of the Cutchalls' claims. Chubb filed its motion after removing the case to the United States District Court and noted that the Cutchalls had not requested any depositions nor done any discovery. The Cutchalls' breach of contract claim failed for two reasons. First, the Cutchalls have failed to point to evidence raising a dispute about whether their claim was covered, and second, the Cutchalls failed to distinguish between covered and uncovered or non-covered damages. Under Texas law, the insured bears the burden of establishing that its claim is covered by the policy. Unconfirmed rumors of loss are insufficient to satisfy that burden. Two of Chubb's experts established that there was no hail or windstorms at the Cutchell's address during the policy period that could have caused the damage they claimed to their house. The U.S. District Court concluded that no reasonable juror could believe the Cutchell's lack of evidence over Chubb's actual evidence, because no genuine dispute existed over whether a covered loss occurred during the policy period. Summary judgment on the Cutchell's breach of contract claim was granted. An insurer also breaches its duty of good faith and fair dealing by denying a claim when the insurer's liabilities become reasonably clear. Chubb investigated the Cutchell's claims and concluded that the covered losses minus the deductible amounted to $27,385.81, and Chubb issued a payment in that amount. The Cutchell's never cashed the check, but it could have been cashed had they so desired. The Cutchell's failed to raise a genuine issue, a genuine dispute of material fact as to whether they suffered additional losses covered by the policy over and above that which Chubb paid, and therefore all of the Cutchell's claims were dismissed with prejudice. In my opinion, it is axiomatic that not every damage to a dwelling is covered under a homeowner's policy. Chubb's experts established some damage, but not the excessive damage claimed by the Cutchell's. Chubb's motion for summary judgment contained convincing evidence that there was no covered loss causing damage to the Cutchell's home, and there was insufficient, if any, evidence provided by the Cutchell's establishing a covered loss. It is insufficient to prove a loss to rely on two adjusters whose lack of expertise and conclusions based on inadequate evidence, which is always, and is in this case, insufficient. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,950 blog postings. Please tell your friends and colleagues about the blog and the videos and let them subscribe. They're free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.